Well, you're really asking me two questions here. One is, how difficult is it to locate the debtor? Usually, this isn't too difficult. We have a variety of tools we can use. We start with what you know and what you can tell us. And then we have access to federally regulated databases that give us certain levels of information. We must certify every time we go into those databases the purposes for which we are using them. And one of the purposes is to prevent fraud. Another is involvement in a civil or arbitral proceeding. These often help us greatly in locating people, obtaining a beginning level of asset history search, not always accurate, and indicating sometimes associates, relatives, family members, work locations, going back sometimes a number of years. In this way, the internet has made our work much easier. It also affords opportunities for the really skilled fraudster to put up false information to further mislead and misdirect people in general. So locating a debtor, we can usually, but not always, do pretty readily. Now, the second part of your question is, how difficult is it to obtain my judgment? Well, the answer is, it depends. I know that's not particularly helpful, but you'll understand in a moment. I will get involved in helping someone obtain their judgment, but it is an entirely different enterprise than you coming to me having your judgment in hand. From the day you start to the day you get your judgment, it can vary from a couple of months to several years. This depends on how hard the debtor wants to fight you, how complex your case may be. Is it just one person got money from you and you're after just the one person? Or do you have to uncover a complex asset structure that is interrelated? I'm dealing with one case right now where, as someone who got a subpoena from us pointed out, we've listed 50 different entities upon which we want books and records if they have them. Everyone in a courtroom or in a lawsuit is entitled to certain discovery, certain protections, and in general, judges much prefer to have matters resolved on the merits than by default. But if someone has been properly served with your complaint and they ignore it, you can go in and get a default judgment, and that usually happens pretty quickly. It's a different quality or timbre of judgment than one that is fully litigated on its merits, but it is just as enforceable, subject to certain limitations in the Uniform Interstate Enforcement of Foreign Judgments Act. It does not have quite the same enforceability in one or two states as a judgment fully litigated, but you have to go through different procedural hoops to secure otherwise the level of enforcement. So I could go on about this for a long time because there are innumerable variations in the answer to your question. And it really becomes fact-specific on the particular circumstances of your case, your situation, the jurisdiction or state in which you're located, whether we're talking about a federal suit, a state suit, and then, of course, the facts of your circumstance.